Supreme Court of the State of New York, County of New York, Criminal Term Part 59X. The people of the State of New York against Donald J. Trump, defendant. Before, indict. Number 71543-2023. Charge falsifying business records. First degree jury trial 100, Center Street, New York, New York, 10013, April 22nd, 2024. Honorable 1 M. Merchant Justice of the Supreme Court. Appearances. For the people, Alvin Bragg, Jr., ESQ, District Attorney, New York County 1 Hogan Place, New York, New York, 10013 BY. Joshua Steinglass, ESQ, Matthew Colangelo, ESQ, Susan Hoffinger, ESQ, Christopher Conroy, ESQ, Becky Mangold, ESQ, Catherine Ellis, ESQ. Assistant District Attorneys Blanche Law by Todd Blanche, ESQ, Emil Bove, ESQ, Netchley's Law, LLP by Susan Netchley's, ESQ, Gedalia M. Stern, ESQ, Attorneys for the Defendant Susan Pierce Bates, RPR, CSR, RSA Principal Court Reporter Lori Eisenberg, RPR, CSR Lisa Kramsky, Teresa Magnicari, Senior Court Reporters. The Court, good morning. The Clerk, the people of the State of New York, Indictment 71543 of 2023. Appearances, please, starting with the people. Emarja Steinglass, for the people, ADA Joshua Steinglass, Matthew Colangelo, Susan Hoffinger, Christopher Conroy, Becky Mangold, and Catherine Ellis. Good morning, everyone. The Court, good morning. Emar. Blanche, good morning, Your Honor. Blanche. I am joined this morning by President Trump and the rest of the team, Emil Bove, Susan Netchley's, and Gedalia Stern. Good morning. The COURT, good morning. Good morning, Mr. Trump. So we have a couple of housekeeping matters to take care of before we get started. People, how long do you expect your opening statement to be? Emar. Colangelo, Your Honor, about 40 minutes. The Court, okay. Mr. Blanche? Emar. Blanche, about 25. COURT, okay. That's fair. Because, unfortunately, we are going to have to break a little bit earlier or a lot earlier than I anticipated. We were informed this morning by juror number 620, who is alternate number 6. You may recall that she had a toothache last week. She was able to make an emergency appointment today at 3 o'clock. Perhaps because of the holiday, I don't know why, that appointment was moved up to 1:20. So, I told her that we can break at 12:30, and I think that's just something we have to do to make sure we don't lose an alternate. Emerja Steinglass, can I just ask you a quick question, Judge? Would it be okay, for logistical and bathroom purposes, if after the opening we take a short break to get our witnesses upstairs and to go to the bathroom? The Court, sure, of course. The other issue is, we received a call on Friday from juror number 9, who was juror number 423, and I did not speak with the juror, but my understanding is that the juror was concerned about the media attention and wasn't 100% sure that she wanted to be here. The juror is here today. I think that we should speak with the juror. See, we have a courtroom full of people. We can do it in my chambers. I'm sorry, in my robing room, and I will ask the court reporter to come in. Your client has waived antimarchy, right? Emar. Blanche, yes, the Court, if possible, I would ask that not every single one of your colleagues come in with us, just one or two, find out what the issue is and see if this juror can continue to serve. The following proceedings were held in Judge Merchant's robing room. COURT, let the record reflect, we are in the robing room. Mr. Bove, Ms. Netchley's, Ms. Hoffinger, Mr. Steinglass, and Mr. Blanche are present. I would ask those of you who can sit, please sit, so it's less intimidating for the juror, and there's another chair here. Maybe Mr. Bove can sit in that chair there, and then we can bring the juror in and she can stand. Sergeant, would like me to shut the door? The Court, when she comes in, yes. Sergeant, juror entering. Whereupon, juror number 9 entered the robing room. The Court, good morning. I apologize for all of this. We need to do everything on the record. I understand that you called on Friday to express some concerns. Do you want to talk about this? Sworn juror, yeah, I calmed down now. It was as soon as I left on Thursday people were figuring out it was me based on what was released. I was a little concerned that it was posted that I live by myself. I am a girl that lives by myself, so I started thinking further into the trial. Started getting nervous that as if more information comes out? Would I need to be worried for my safety? I was a little uneasy once there were things being posted about me that I didn't necessarily anticipate was going to happen. The Court, how do you feel today? Sworn juror, feel better today. Feel grounded. Obviously, the gravity kind of set in and I just hope that I can continue to stay as anonymous as possible. I live by myself, was posted that I live by myself. I had concerns if my name were ever to get out there, obviously, that poses a safety risk to me, and that was really my biggest concern, if anyone ever figured out where I lived, and that I lived by myself, that I wouldn't be safe, that was really my only concern. Courtie can appreciate that. Just a couple of things that, hopefully, will reassure you. First, the jury was the story last week. Hopefully, I expect that the jury will no longer be the story. Sworn juries, yes. The Court, second, it's not entirely possible to read the description and know who would know that it was you. Not surprising, so that works out. You know, if anything were to change, if there ever comes a time when you feel like you can't do this, just bring it to my attention. You should know that after the first day, I did speak to the press from the bench. I expressed my disappointment with how much information got out, and since that time it's really been very different. All right? Sworn juror, yes. The Court, anything else you want to tell us? Sworn juror, no, it was just safety concerns. Thank you. The Court, thank you. You can go back to the jury room. The COURT, anything anybody wants to put on the record about that? Emerja Steinglass, no. Emar. Blanche, no. The Court, are you comfortable with her staying on the jury? Emar. Steinglass, yes. Ms. Hoffinger, yes. The Court, we are back on the record. Juror number 9 is going to remain with us. That's not going to be an issue. Again, just a couple of housekeeping matters. One of the issues that were raised at the end of last week had to do with the limiting instruction regarding Michael Cohen's guilty plea to FICA violations. The people submitted a version, the defense submitted a version, I reviewed them both, and, ultimately, I drafted my own, which is really, it's consistent with what I would normally do. So let me hand it down, you can take a look at it, let me know if you have an objection to it, there is still plenty of time to correct anything that's a problem. Mr. Steinglass, thank you. The court, you're welcome. Mr. Steinglass, that's fine. The court, anybody wish to be heard on that? Mr. Steinglass, we have no objection. The court, counsel? Mr. Blanche, nothing new, Your Honor the court, thank you. There was also an issue regarding an Access Hollywood tape last week and to what extent the people would be permitted to elicit information about it. I promised I would go back and review the transcript. I did, I don't really see the confusion. The issue of the people introducing a transcript was never raised or not raised, or what was raised was that the people would be permitted to go into what was discussed in the Access Hollywood tape and that the tape would not be played. If the people were to request and seek to introduce a transcript, I would hear argument of both sides as a matter of evidence, not as a matter of this is the Access Hollywood tape and, therefore, some special rule applies. At this point, I don't see any reason why a transcript which accurately summarizes what was said in the tape should not be admitted into evidence. Mr. Steinglass, thank you. Cordy will hear you on that. Mr. Blanche, Your Honor, we, obviously, objected for the reasons we put in our letter and the reason we talked about last week and continue to object, but Your Honor has ruled. The court, thank you. Finally, we did have the Sandoval hearing last week on Friday, and I will read my ruling from the bench. This court conducted a Sandoval hearing on Friday, April 19, 2024. At that time, the people disclosed the list of all misconduct and criminal acts of the defendant not charged in the indictment, which the people intend to use at trial to impeach the credibility of the defendant pursuant to CPL Section 245.20, Subdivision. The people referred to 6 different proceedings involving a total of 13 determinations. The defendant contends, among other things, that prior conduct is too similar to the crimes to which he is being charged and will permit the jury to infer guilt from propensity based on the priors. The court has considered many relevant factors and balanced the prejudice to the defendant against his willingness to advance his own self-interest in reaching the Sandoval compromise. The operative standard is familiar and, therefore, briefly repeated, is well settled that the scope and content of cross-examination rests within the sound discretion of the trial judge, that's People v. Sandoval, 34 New York 2D 371, 1974. The court, in exercising its discretion prior to trial, may limit the people's use of the defendant's history of criminal, vicious, and immoral acts to impeach the defendant with cross-examination. Sandoval at 373. The judge balances the act's probative value on questioning the defendant's credibility against the risk of unfair prejudice resulting from their admission. At 375. There is no precise formula in determining which prior acts are appropriate impeachment material. People v. Walker, 83 New York 2D 455, 1994. The trial court's analysis is not bound by the age, nature, or number of defendants' prior crimes. People v. Gray, 84 New York 2D 713. A defendant can even be impeached with prior acts or prior bad acts that did not result in a criminal charge, and that's Gray citing Sandoval. Indeed, a trial court might exclude such evidence entirely, may alternatively limit inquiry to the mere fact that there has been a prior conviction. It may limit the inquiry to the existence and nature of the prior conviction, or it may permit examination to the facts and circumstances underlying the prior conviction. People v. Hayes, 97 New York 2D 203. Thus, even a ruling that permits cross-examination regarding a defendant's entire criminal record does not without more indicate an abuse of discretion. People v. Walker, 83 New York 2D at 458. In short, the ultimate question as to whether to permit such impeachment is a matter that rests with the trial judge, who exercises a wide range of discretion, and that's People v. ruling on a Sandoval application. Contreras 108 AD 2D 627. Moreover, as far as probative crimes withdrawn. Moreover, as far as probative crimes go, the mere similarity of a defendant's prior conviction or prior conduct to one of the crimes charged does not automatically preclude cross-examination. That's People v. Paveo, PAVAO, New York 2D 282. That case dealt with violence. The principle was the same. The mere fact that the conduct was similar does not in and of itself preclude going into it. It has long been recognized that a defendant cannot shield himself from impeachment on the basis of frequency of his offense or his tendency to specialize in a particular type of crime. People v. Rahman, RAHMAN, 62 AD 2D 968. It is settled law that a criminal defendant who chooses to testify on his own behalf may be cross-examined about any prior criminal, vicious, or immoral acts that bear logically on his credibility, including those acts by defendant that did not result, again, in a criminal conviction. This court is not required to preclude the people from asking about the incidents because they might keep the defendant off the stand. People v. Hayes. The Court of Appeals has stated that the alleged singularity of the defendant's testimony does not require the court to limit otherwise appropriate impeachment material. In fact, courts have recognized that if the defendant is the only witness, it may be that much more important that the jury be able to access his credibility accurately. Thus, the possible unavailability of other witnesses may cause the trial court to conclude this factor increases the importance of defendant's credibility. Of course, fairness dictates that the court must be mindful of the potential prejudice to the prosecution in the fact-finding process denying the jury access to probative evidence of the defendant's credibility. People v. Bennett, BENNETTE, 55 New York 2D at 147. Finally, any perceived unfair prejudice by a permitted inquiry may be alleviated by the court's careful and specific limiting instructions at the time of cross-examination and, again, during final charge. In fact, the court in clear and forceful language should instruct the jury that they are to consider the defendant's previous conduct only in assessing his credibility and under no such circumstances are to use his prior conduct as proof that he committed the instant crime. Given those precise instructions, which the jurors are presumed to follow, People v. Davis 58 New York 2D 1102, the court is permitted to reach a Sandoval compromise. Upon applying that law, if defendant takes the stand, the court will permit the people to inquire into the following 6 determinations involving 4 separate proceedings. First, as to the proceeding of People by James v. Trump, index number 452564, document number 1688, the court will allow the people to elicit that on February 16, 2024, the defendant was found to have violated Executive Law Section 63 by fraudulently misstating the value of his assets for an economic benefit. The court ordered the defendant to pay penalties and enjoined the defendant from serving as an officer or director of any New York corporation for a period of 3 years. Next, document number 1584, the court will allow the people to elicit that on October 20, 2023, the defendant violated a court order by failing to remove untrue, disparaging and personally identifying post about the court's principal law clerk from the website, DonaldJ.Trump.com. The court fined the defendant $5,000. And the third document from that incident, document number 1598, the court will allow the people to elicit that on October 25, 2023, the defendant was found to have intentionally violated a court order by making public attacks on the judge's law clerk, despite 2 prior court orders not to do so. The court fined the defendant $10,000. Moving on to the next proceeding, and that would be Carroll v. Trump, 22, CV, 7311, and that would be ECF number 214. The court will allow the people to elicit that on September 6, 2023, the defendant was found to have defamed Jean Carroll in public statements in 2019 by making false statements with actual malice. As to the next proceeding, that would be Carroll v. Trump, 22, CV, 10016, and that would be ECF number 174. The court will allow the people to elicit that on May 9, 2023, the defendant was found to have defamed Jean Carroll in public statements made in 2022 on Truth Social by making a false statement with actual malice. A jury awarded the plaintiff compensatory and punitive damages. And the fourth one would be People by James v. Trump, index 451130 of 2018. The court will allow the people to elicit that on December 11, 2018, the defendant stipulated to the dissolution of the Donald J. Trump Foundation to resolve claims by the New York Attorney General that he engaged in repeated and willful self-dealing transactions. The court has struck this compromise in order to permit the defendant to testify in his own behalf if he chooses to. In doing so, the court has excluded inquiry to some degree into each of the 6 proceedings, including 2 proceedings that the court will not permit any inquiry at all. Further, the court has greatly curtailed the extent to which the prosecution may inquire into the underlying facts, the specific claims or charges, and the amounts of the significant penalties. The court cautions defendant that this Sandoval ruling is a shield and not a sword. After a trial court has made a Sandoval ruling, a defendant who offers misleading testimony about his background and prior conduct opens the door to questioning that otherwise has been excluded. People v. Fardan, Fardan, 82 New York 2D 638, at 645 to 647. Would you like to be heard on that? Mr. Blanche, no. The court, I believe, that takes care of all of the preliminary matters. Can we bring the jurors out? Mr. Steinglass, Judge, I wanted to clarify the record on one point. The Sandoval materials, including the chart, was provided to defense counsel pursuant to your ruling back on March 10 of 2024. Other than that, there is no reason we can't bring in the jury. The court, okay, let's get the jury, please. Sergeant, jurors entering. The court, all rise. Whereupon, the sworn jury entered the courtroom and were properly seated. The court, please be seated. Good morning, jurors. Welcome back. Members of the jury, we are about to proceed with the trial of the people of the state of New York versus Donald J. Trump. At the outset, I am going to explain the various stages of a trial and what you may expect to see and hear during the trial so that you may better understand what is taking place. I will also remind you of some basic principles of law which apply to this and all criminal trials. At the conclusion of the case, I will again remind you of those principles. I will define the crimes charged, explain the law that applies to those charged crimes, and list for you the elements that the people must prove beyond a reasonable doubt. These introductory instructions will take about 30 minutes and may sound similar to what you heard last week. As you can see, a court reporter is taking down everything that is being said. What the reporter takes down is called the record of the trial. Sometimes you will see a witness use his or her hands to illustrate something. For example, a witness may say that an object was this far away, indicating with their hands. Normally, we will then hear the lawyers, or the court, say something to the effect of, let the record reflect that the witness is indicating about a foot. We do that because sometimes it becomes necessary to have the court reporter read back what a witness has said or what a witness is indicating. If somebody does not say orally for the record that the witness is indicating with his or her hands, when that portion of the record is read back we may not remember what the witness has indicated. You of course will be able to see with your own eyes and you can make your own judgment. The trial formally begins with what the law calls an opening statement by the prosecutor. The law requires the prosecutor to make an opening statement. The law, however, does not require the defendant to make an opening statement. If the defendant does not make an opening statement, that is not a factor from which you may draw any inference unfavorable to him. Remember, what the lawyers say in an opening statement, or at any time thereafter, is not evidenced. The lawyers are not witnesses. What I say is not evidenced. I am not a witness. You must decide this case on the evidence and remember at all times that what the lawyers say at any time is not evidence. After the completion of the opening statements, the prosecutor will proceed with the presentation of evidence. I remind you that the indictment is not evidence. It is simply a document that contains an accusation. Defendant has pled not guilty to those accusations, and a trial is for you to hear the evidence and decide whether the defendant is guilty or not guilty. I remind you also that evidence is the testimony of witnesses, the stipulations, if any, that are agreed to by the parties, and documents or other physical objects which are received in evidence. Testimony is, of course, the most common form of evidence and comes from the questioning of the witnesses by the lawyers, and perhaps by the court. A question by itself is not evidence. It is the question with the answer that is evidence. Sometimes a question will assume, for example, sometimes a question will assume something to be true. You are not, however, to conclude that an assumption in a question is true unless the answer in your judgment confirms it to be true. So you must consider the question and the witness answer and decide whether you find the answer believable and accurate, because, again, it is the question with the answer that is the evidence. Next, evidence may come in the form of a stipulation is information which both stipulation. Parties agree to present to the jury as evidence without calling a witness to testify to that information. Thus, evidence may come in the form of physical items such as documents, photographs, clothing, or charts. When a lawyer is questioning a witness and in a question refers to a physical object for the first time, the object is normally marked with a number or a letter of the alphabet so that we can more easily identify the object and refer to it. That procedure is very helpful in keeping track of physical objects. Sometimes, depending on the type of physical object, it may be too difficult or inconvenient to mark the object, and the object is deemed marked rather than actually marked. Normally, when the object is first referred to, a lawyer will ask the court to have the object marked for identification. If the people make the request and the court grants the request, the object is indeed marked with a number. If the defendant makes a request and the court grants the request, the object is deemed or marked with a letter of the alphabet. That just helps us to remember who introduced the exhibit. Sometimes, to save time during the trial, we will